Hi there. Welcome to Keystone Law Firm's Legacy Lockdown for Steps to Retirement. My name is Michelle Dexter. I'm an attorney here at Keystone Law Firm, and we like to do some of these webinars and give people an idea of information to help keep them up to date on their estate plans, help keep them educated about their options, and just generally keep this type of information at the front of their minds. Keep in mind that this information today is for educational purposes only. It's not intended to give you specific legal advice. We do encourage you to speak with an attorney directly to learn more about how your specific situation should be handled if you find anything in this webinar today that you determine is more beneficial to you and would like to discuss a little bit more. Today's agenda, we're going to start with minor children, some of the things that happen with regards to them, including conservatorships versus trusts, guardianships, special needs, what can happen with life insurance and retirement accounts. But we're also going to talk about beneficiary protections and what things to look for as your beneficiaries become young adults, middle-aged beneficiaries, and even older beneficiaries. All right. So let's get started. When we're talking about minor children, as those of you who have had children know, there are definitely very big ranges for our minor children. We start with the newborn baby stage where they really can't communicate to you their needs. They move into the school age where they're very busy with activities. And then we move into college age where it seems like they need us a little bit less, maybe more financially and more socially. All right. So we definitely want to talk about all the different levels of keeping in mind that even within the term minor children, there's a lot of range there that you can be considering. All right. So conservatorships versus trust. Okay. A trust is a document that you can create independently of court that can designate who it is that's going to handle money for your beneficiaries and yourself in the event that you can't manage it for them or yourself. All right. A conservatorship is a court-appointed person who is designated to make financial decisions for you or receive beneficiary distributions for somebody who's under the age of 18 or who may have an incapacity issue, okay? When you are distributing your assets to especially a minor child through a trust, you are designating who is going to manage that money for them, who is going to be in charge of it. If the first person can't, you can have your plan A, your plan B, your worst case scenario lineup of people. But also you can kind of designate what are these funds going to be used for? Are they intentionally going to be used for their education? Do you want to have any restrictions on them? Do you want them to be able to get them at a certain age? When you've got a conservatorship, when that person turns 18, assuming that they otherwise have capacity, they go back to court and the court is going to release that money to them. For those of you who have a legacy and have money that you want to pass on to the next generation and maybe even your grandchildren, you want to make sure that that money is being well spent. You don't want to think about an 18-year-old who may receive the money and think, wow, I'm rich. I don't ever have to work again. Or I'm going to go out and buy the fastest, best sports car that's on the market. Or I'm just going to make a choice with this money that does not save it long term, which may be what your goal is to give them the ability to buy a house in the future, or to save up for retirement in the future, or to just generally make their life better, where their immature brains may not realize the benefit of holding on to that money and saving it. And so by having a trust, you can kind of force some of that delay in distribution. You can force the conditions that are around that a conservatorship, once they turn 18, won't do. Okay, so when we're comparing a conservatorship versus a trust, the first thing is cost, right? A trust is going to be significantly less expensive than having a conservatorship for your beneficiary. The cost of going to court is going to be generally, if you're hiring an attorney, probably $10,000 to $15,000 to do it. Our basic trust package is about a $2,000 package right now here in early 2026. So you can see that is a significant financial difference. With regards to privacy, the conservatorship documents are court filed. That means that they can become part of the public record. With a lot of the stuff for minors, we will do our best to mark it as confidential, but it may still release more information than you really intended to have released. And so with the trust, that doesn't have to be filed or recorded anyplace public. And what those beneficiaries will be receiving can be kept out of the court proceedings and out of the public view. Okay. Does a conservatorship and a trust both protect a beneficiary? They do. Both of them have requirements that the person who's in charge of the money does a beginning inventory, that they do regular accountings. The difference is that with the conservatorship, those accountings and that inventory and budget have to go through the court process. The accountings get approved by the court accountant. There is a hearing on it and a whole approval process. When you're doing that for the trust, it can be a little more informal, right? The trustee still has fiduciary duties to the beneficiaries to make sure that they're using the money for the ward or for the beneficiary's best interest, but it's not as intense, it's not as court controlled as a conservatorship would be. And so going with the trust is generally an easier way to do it. In terms of the termination, a conservatorship, assuming again that they are at the time they turn 18, that they have capacity, they're going to file a petition with the court and get a court order to terminate the conservatorship. And then those people are going to receive those funds at the age of 18. For most of us, we recognize that most beneficiaries, their brains aren't fully developed until closer to 25. I have some clients that want that to be pushed out even farther. I have an occasional client that says, you know, my beneficiary is really mature and I want that brought down to 21. But I think for most of us, we can agree that 18 is pretty young to get a significant amount of money. All right. Additional things that you want to consider when you are looking at a conservatorship, there are, in addition to the costs for the person who wants to be appointed conservator, there's an attorney for the court that comes with an expense. There's a court investigation that comes with the expense. The conservatorships through the court have a little bit more limited investment opportunities, okay? The court is going to want that money that's being held until the beneficiary turns 18 to be making some money, but you can't be very risky with that money. You can't do some of the things that you might otherwise do. And so you're somewhat limited in what your investment opportunities are when you're going through a conservatorship. The trust still has conditions. Again, you've got fiduciary duties as the trustee to the beneficiary to make sure that you are smartly investing those things, but you have a little bit more of an investment opportunity. The other thing is with regards to access. When you've got a conservatorship for somebody who's under the age of 18, typically those funds are just restricted until that person turns 18 and then the money is released to them, okay? If the conservator determines that they need to access that money, then they're looking at a bond, they're looking at budget, they're looking at the annual accountings to account for that money. And in addition, the court isn't really keen on spending a kid's money for things that maybe a parent or a guardian should be paying for, right? When it comes to the trust, we're going to have a little bit more flexibility on that, right? If the beneficiary is older than 18, you can still choose to limit the beneficiary's access to the funds without declaring an incapacity. And so again, you know, if we say you're not going to have direct access to this money until you're 25, that's something we can only do through the trust. We can't do that through the conservatorship, all right? When we've got minor children, the other concern is guardianship. So guardianship is who's going to take custody and handle the medical decisions for the children, right? If you have an estate plan, and you know, if I still have one minor child, right? He's almost 17, not quite a minor, but he's still technically a minor. Without an estate plan, I'm basically leaving it to the court to decide. With an estate plan, I can designate who will have priority for him to go to in terms of custody if I'm not available to take care of him, right? So with an estate plan, you can have a testamentary appointment in your will that allows the guardian to file an acceptance and effectuate that guardianship. You can also choose people for temporary and permanent guardianship situations to help avoid that child going through child protective services. You can have a preference for your priority, but the way that the law reads is that if that minor child is 14 years old, they can also object to that appointment. So they can start to participate in the conversation at that point in time, just as kind of a caveat. If you've left nothing, no writing, no estate plan, no will, and you're leaving it to the court to decide, it's going to require a court hearing. It may require several court hearings. It may even require a trial, because it depends on how many people are kind of competing for that position as guardian. Excuse me. When we have people competing for guardianship of a minor child, when there's uncertainty of who the child's going to go with, that can be very stressful on the child. And so by having the estate plan and having that plan kind of laid out, it can help reassure them during a really stressful time when they may have lost their parents. In addition, when there's no clear front runner for who's going to be guardian, it can result in the children going to Child Protective Services and staying in their custody while the custody dispute is being resolved. For most of us, that is definitely the worst case scenario, and we prefer not to have that. So people that have young children should really be considering having some kind of documentation in place to leave a plan and setting these things up, because the guardianship aspect is an important part of it, as well as the conservatorship or having the trustee with the trust to be able to manage the money. Now, for some people, who is going to be the guardian and who is going to be the trustee to manage the money may be the same people, may be different people. It's kind of a personal decision in terms of whether or not you want the person who's going to be guardian of your child to have full access to the money to provide them with the lifestyle that they're accustomed to living, or whether you would prefer to have some checks and balances to make sure that the guardian isn't necessarily overspending or misusing the money that's intended to be left for the child. And so those are just kind of two different viewpoints. I know sometimes the person that I would want as guardian isn't necessarily a strong financial person. And so that may be another reason to kind of split up those duties and have different people for different portions of it. When you have young children too, or even your older children, depending on what their situation is, special needs is something that you definitely want to take into consideration. If you have beneficiaries, whether they are your own children, whether they are grandchildren, whether they are nieces and nephews, or some other beneficiary that you intend to leave for, if they're born with any kind of neurodivergent issues, physical disabilities, mental health issues, that is definitely something that you want to be figuring out how you're going to set that up for them, so that they don't get disqualified for any benefits, okay? When we have beneficiaries that have these types of special needs, and special needs generally carries over into they qualify for some kind of government benefit that helps pay for maybe their health expenses, maybe it pays for food, maybe it pays for housing, those types of things. And we don't want those people that have qualified for those benefits to lose them as a result of receiving a distribution from your estate, because what's going to happen is they're going to be disqualified from those benefits. They're going to have to spend down the money that they've inherited, and then they're going to have to re-qualify for those benefits, right? So it's not necessarily going to happen the way you think if you don't plan for it accordingly. And so making sure that you understand what's going on with your beneficiaries, especially if they're not directly your own children, and understanding what types of disabilities they may be dealing with and whether or not they qualify for any kind of government benefits is important to know, so that you can properly set that up for them. A special needs trust is set up to help avoid losing government benefits. A lot of times those are what we call first party special needs trusts, and they will allow for a government agency to get reimbursed for expenditures that were made while the trust was in place, okay? These are often created by people who are receiving an inheritance and don't want to get disqualified from the government benefits that they're receiving. So they create this trust as a special needs trust with the promise that when they die, anything that's left in the trust is going to repay the government for the payments that they've made on behalf of that beneficiary. When a person creates a supplemental needs trust for a third party, so you're creating that now for your beneficiary, it will help avoid the loss of the government benefits, but without a reimbursement expectation. So the government doesn't expect to be reimbursed out of these supplemental needs trusts that are what we call a third party beneficiary trust, because they aren't entitled to the reimbursement. You can't set this up for yourself. You've got to set this up for somebody else. But as you're considering who your beneficiaries are and what issues they may be dealing with, you want to make sure that you're taking these things into consideration. Because again, when you're looking at maintaining the legacy of money that you want to share for future generations, intentionally knowing that those funds are going to go to a government agency instead of your successor beneficiaries is not protecting that money. And so this is a really important thing to take into consideration. We have a lot of kids nowadays that are on the autism spectrum. Some of them are very high functioning, some of them are very low functioning. It's important that you understand, if any of your beneficiaries have these situations, what your options are, how you should set up your trust, because they may be young enough that you don't know how high functioning they're going to be when they inherit from you. And so it's important to have that conversation with your attorney, as well as with the parents of that child, to help understand what the expectations are for their success and what you can do to help make sure that you're setting up your legacy to continue on for their benefit for a very long time, and not just a short period of time where they're off of benefits because they were disqualified. Things I want you to consider. Life insurance. A lot of times life insurance has beneficiaries specifically named in them, right? And then they may have a contingent beneficiary, okay? If proceeds from a life insurance policy are owed to a minor, child, or an incapacitated person, that life insurance company is going to require that they have a conservatorship in place, okay? Again, for those that are under 18, a conservator is going to be opened. They're going to receive those life insurance proceeds, and then they're going to sit on that money until the kids are 18, generally in a fairly low interest-bearing account. And so it's kind of unfortunate that there's not more money being made off of those funds while they have to sit waiting for the child to turn 18. Similar, if we have an incapacitated beneficiary, there's going to be this conservatorship that's needed. But if that incapacitated beneficiary is also receiving government benefits, this life insurance money may do just what we talked about and disqualify them from the benefits without having that special or supplemental needs language in the trust. So if we can name the trust as the beneficiary, that's going to help us avoid a conservatorship. It can help us avoid the loss of benefits through the government, and it can also have better contingency plans than what the beneficiary forms allow for. Sometimes those beneficiary forms just allow you to name your first choice and your second choice. Sometimes they'll allow you to say per stirpies, but you really need to understand what's going to happen to those funds if the people that you're naming on there aren't there to receive it. Is it going to their probate? Is that where you want it to go? If you have the trust named as the beneficiary of your life insurance policy, then those funds can come into your trust and they can be distributed pursuant to all the contingency plans that you have, okay? When the proceeds are paid to the trust, it allows the trustee to manage the funds. And so they can put it into a better investment vehicle to try to earn more money. They can put it into a higher rate CD. They've got more flexibility with how they manage that money than if it goes through a conservatorship and has to be restricted by the court, okay? Of course, the proceeds paid to a trust also allows the trustee to continue managing those funds for beneficiaries that are younger than 25, or if you choose to move that 25-year age up, you can do that. Otherwise, again, through the conservatorship, they're going to get that money at age 18. And, you know, depending on the amount of money they are going to receive, they may just think that they're going to be rich, you know, so that's a problem. When you're looking at retirement accounts are similar to life insurance in terms of if the beneficiary is under the age of 18 or incapacitated, then a conservatorship is going to be needed, right? When we're dealing with beneficiaries of retirement accounts that are minor children, they have until they turn 21 plus 10 years to pull that money out of the retirement accounts. Okay. And so the Secure Act passed a few years ago is what kind of put that in place. And so you definitely want to be considering, if we're going to have money coming out of this, how much money are we dealing with? What is the tax consequences of pulling the money out of the retirement accounts? And what can we do with that money until the kids are old enough to be receiving it? When we're looking at just your typical healthy beneficiary that's not critically ill or permanently disabled, or a spouse, or not less than 10 years or not more than 10 years younger than you, everybody else is going to have 10 years. If they fall into one of those categories, spouses, disabled vehicles, chronically ill, they can have a longer stretch. And so it's important to know, when you're naming beneficiaries for your retirement accounts, who are your beneficiaries? How do they fit into this? And, do you need some kind of protections in place? Do you need, supplemental needs language? Do you have minor children? Do you want to do something that we call a standalone retirement trust that could be named as the beneficiary of those retirement accounts to help allow somebody to manage it without going through the conservatorship process? All right. One other things that you want to consider when you're looking at people that are under the age of 18, as well as incapacitated beneficiaries, as well as really anybody, are beneficiary protected subtrusts. And a beneficiary protected subtrust allows each beneficiary to receive their share in a protected subtrust. When we're creating those subtrusts, it's a pretty wide range in terms of how distributions are going to be made, who's going to control it. And so we've got everything from, I'm not terribly worried about their ability to handle the money, I'm okay with them having direct access to it and using it for what they want. But I like the fact that the money that's kept in that trust is protected from a dissolution of marriage, is protected from any creditor issues they may have, it's protected from any liabilities they may have, right? And so that's like one range of it. You move over a little bit, maybe it's a little more restrictive. Maybe they can't manage the money themselves until they're a certain age, whether that's 25 or 30 or 35. Maybe we're limiting what they can use the money for to education till a certain age, or certain things that we want them to be employed, or we want them to be going to school, or we want them to be doing certain things. And then the other far end is they're never going to be their own trustee. We may have drug testing requirements. We may have very specific, strict restrictions on it. And so the beneficiary protection subtrust can kind of fall anywhere in that category. You can also designate who is going to receive the assets if the initial beneficiary hasn't spent it all, right? So if I say to my child, but if he doesn't spend it all, then to his children, or he doesn't have children, so back to his brothers, or his brothers aren't there and I want it to go to charity. I can set that up so that it's very specific in terms of what would happen if plan A doesn't work out, if plan B doesn't work out, if we're in our worst case scenario, okay? In addition, as I mentioned, those assets that are kept in those beneficiary protected subtrusts are protected from a dissolution of marriage of the beneficiary, their own creditor issues, and their own liabilities. And so sometimes those are things that you don't necessarily expect to happen to that beneficiary, but people change, marriages change, different things happen. And so you just want to be cognizant of how much money is that person inheriting, how are they with their money, and we'll talk a little bit about that. All right. So the age can really make a difference when you're looking at protecting your legacy, right? When we're talking about young adults, we're talking kind of college age through their 30s, right? They may not have a lot of their own assets yet, so they may not be financially savvy. They may have debt, student loans, credit cards, and they may be starting a family, which is going to be even more debt for them, right? So you want to consider, if they don't have a family and the beneficiary was to pass before spending it all, who's plan B, right? Who would you want to receive those funds for somebody who's on the younger side and maybe doesn't have kids of their own? And, outside of a subtrust and inside of a subtrust can have different answers. So if I say everything to my 22-year-old son outright, he's going to be able to receive that, and he's going to be able to go put that in his bank account, and he's going to be able to designate where that money goes to. If I say it's going to go to my 22-year-old son in a beneficiary protected subtrust, and he's not going to manage it directly until he's 25, and he passes, and there's still money in that subtrust, I can direct where that money's going to go. And so it's kind of a matter of, what do you want your legacy to be? Do you want it to be just passed off to somebody and then they get to decide from there? Or do you want to decide, look, if they don't spend it all, then here's what my plan B is, okay? You want to consider, when you're looking at beneficiaries that are in that young adult category, what is their financial maturity? Are they capable of managing this money themselves, or do you need to put somebody in charge of managing it for them to a certain extent? What are their personal obligations? Do they have student loans? Do they have credit card debt? Are they renting? Are they living paycheck to paycheck? How are they managing things? And are they going to be successful with this, or are they going to just go out and blow it? And are they going to be influenced by the people that are their friends that think, hey, this is great that we came into some money, let's go out and party, right? I always want you to consider your beneficiary depth chart. I call it the depth chart because my son plays football. And so how many people are there, right? I have 3 sons. So my depth chart is basically 3 children. As they start to have family of their own, my depth chart is going to increase, right? And so if my 3 kids each have 3 kids, I go from 3 people to having 12 people, 3 plus the 9. And so that deepens my depth chart in terms of, if one beneficiary isn't there, I still have other beneficiaries. But sometimes when we have clients that only have 1 child and they don't have any grandchildren, we want to be planning for what happens if that child isn't there to receive it. What is plan B and what is worst case scenario? Sometimes that may be your personal siblings, that may ultimately be a charity. But again, you've worked really hard to accumulate and earn all of this money. We don't want it just going places that you didn't plan for it to go. So thinking it out and determining where that money is going to go if the first plan doesn't work out is really important to protecting that legacy, okay? And then finally, with those young adults, do they need protection from themselves, right? Do we need to make sure that they're not going to go out and make bad choices with the money, that they're not going to be influenced by their buddies and just really waste the opportunity that they're being given with this money that they're inheriting because they just aren't mature enough to understand what that looks like, okay? When we're talking about middle-aged beneficiaries, we're talking about people that might be 40s, 50s, 60s, right? Some of them may have their own wealth. And so we need to start considering, if we're adding to their wealth, what does that do, right? They may be a high income earner. If they're a high income earner and now they're going to start receiving pre-tax IRA or 401k retirement benefits that's going to be taxed at the highest tax rate, is that still the smartest decision for what you want to have happen with your money, to where more money is going to be used to be paying taxes versus benefiting somebody? And what does it say if your middle-aged beneficiary is still struggling financially? Are they capable of managing a decent amount of an inheritance? And is that a responsible thing to do, to give that to them right off the bat, right? You also want to consider who's going to receive your assets. Is it time to consider distributions to grandchildren? Do they have enough wealth that maybe they don't, your kids don't need the money, and maybe we should be trying to benefit the grandkids that may be trying to create their own life and benefit them a little bit? Is your beneficiary on their first marriage or their third marriage, right? When we're looking at beneficiary protected subtrusts, that can make a difference. If your child has been divorced several times, you don't want them to inherit this money, go and put it into a joint account, and then get divorced again. You want to make sure that those funds are going to stay with your child and not with the ex-wife. And so you definitely want to take those things into consideration, okay? Also, as I mentioned, if they receive your retirement over 10 years, what does that mean in taxes? We definitely want to be taking that into consideration. For some people that have a significant amount of retirement money that are concerned about those taxes, you may talk to your financial advisor about doing a Roth conversion or just pulling more money out every year before you hit that next tax bracket level and trying to minimize the taxes that are going to be paid on those distributions, all right? You also want to keep into consideration, are their children healthy? Because again, if we have a grandchild with a disability, or some kind of issue, then we need to be considering those supplemental needs trusts. Are the grandkids smart with their money? Because I don't want my grandchild to be getting money that they're just going to go out and blow. It's, the same type of thing. Are they going to be making good choices? Do we need to protect them from themselves? If they inherited your money and your legacy, are we doing what we can to make sure that they don't just go out and blow it? You worked really hard. You could probably saved and scrimped and made a lot of hard choices. We don't want to turn around and just let them go out and blow it, right? And then we've got clients that have older beneficiaries. Their children may be retired. If they're retired, they may or may not be financially stable. If you've got a child that's still having to work a part-time job to make sure that their expenses are paid, I want to consider whether or not handing them a big chunk of money is in their best interest, or do we need to have somebody else oversee that for them for a while? Do we need to have guidelines on what distributions are? Do any of your older beneficiaries have their own health issues, right? Because if they are trying to strategize to get government benefits like the Medicaid program, we don't want them to inherit this money and then have to spend that down before they qualify for those benefits. So in addition, I've had some clients recently where the beneficiary, their older child had a stroke 10 years ago. They never updated their documents. And now that beneficiary is actually receiving government benefits, but they're inheriting directly from their parents because their parents never went back and updated their documents to account for the fact that their child who had had a stroke and is receiving government benefits can't inherit outright a whole bunch of money. That money has to come to them through a supplemental needs trust. And so we've got a number of client cases right now where we've got beneficiaries that really can't receive those large amounts of money without being disqualified from their benefits. They're not in a position, they're not able to disclaim the money. They're not able to say, you know what, I pass, I don't want that. Because from the government standpoint, the government wants you to use the money that you have available to you to pay your own expenses, which is perfectly logical. The downside, though, is that had the parents or the people that passed away, had they set up their trust, had they reviewed it, and had they made the changes and the corrections to it, this wouldn't be a situation at all. And those people could keep their benefits and receive the money that would help improve the quality of their life. So you definitely want to be reviewing these documents periodically and looking to see how are your beneficiaries doing financially, health-wise, in terms of all of their needs, okay? Their needs as an older beneficiary can be different than when they were younger. And so you just want to kind of do a whole picture evaluation, all right? When you look at who's going to receive your assets, sometimes I have clients that are saying, I have a relationship with my child, but I really don't have a relationship with my grandchildren. So you have to ask yourself the question, do I want my legacy to continue forward to the people that I don't know? Or would it be better served to a charity or people that I do know or people that I do care for? So, unfortunately, not everybody has the ongoing relationships with their grandchildren. And so you want to take that into consideration. And, do you want to consider charities as beneficiaries? Sometimes when we're looking at legacy, right, charities are a great way to make sure that your legacy kind of carries on. And whether that's, through creating a scholarship that might be in your name, whether it's having, even just a bench at your college or your favorite zoo spot or whatever, there are lots of ways to kind of carry your legacy forward with that, okay? Things that you want to consider when you have older beneficiaries is, have you reviewed your estate plan and have you checked the needs of your beneficiaries? Have any of those changed, right? Don't assume that everybody's doing well. Sometimes it's an awkward conversation, but you have to have the conversation to know what's really going on with them. Is a supplemental needs trust something that's needed and it's definitely needed if they're receiving what we call means-based benefits. Means-based benefits means that they can't have more than a certain amount of money in their name, okay? Generally for Medicaid here in Arizona, that's about $2,000 that you can have in terms of resources. So if they're going to receive $10,000 out of your estate, they're going to be disqualified. They're going to have to spend down that $10,000 to $2,000, and then they're going to have to requalify. If you've ever tried to qualify for government benefits, it is a painful, long process. They often come back to you and ask for the same things over and over again that you feel like you've already distributed to them. They will take a really long time to answer you and then give you a really short time to respond. And sometimes it can be several months before you get qualified, and that's a really stressful position to be in. So you want to make sure that you have are taking into consideration the needs of your beneficiaries at whatever age they are, so that you're making sure that those funds are going the way that you intended and that your legacy is really being treated the way that you want it to be treated. All right. So when we're looking at beneficiary options, there's really kind of a range based off of their needs and your intentions, right? When you're looking at locking down your legacy, if you do nothing, you're going to end up without an estate plan for your family. Could very well be forced into court to manage your affairs during your lifetime and after your death. There's not going to be any directions for minor or incapacitated beneficiaries. There's no contingency plans. And if you have beneficiary designations on specific accounts, you're going to want to make sure that you're reviewing those on every asset, and you're reviewing those regularly, okay? You're also going to want to make sure that you understand what happens if the people that you've named are not there, and where would those funds ultimately go, okay? For those of you who are just interested in doing a will and you think, all I need is a simple will, I don't have very much, keep in mind that having a will is just directions to the court on how to direct your assets. It's not avoiding a court filing. And so the will is intended to be the directions to the court. In addition, keep in mind, you're still going to need financial and healthcare powers of attorney to keep you out of court during your lifetime and avoid a guardianship and conservatorship. Otherwise, you may still need those. In addition, your beneficiaries, if they're minor or incapacitated, may still require a conservatorship unless your will is really specific. And then oftentimes what that's doing is it's saying, look, if any of my beneficiaries are under a certain age or incapacitated, then my will is going to create a trust. So you might as well have just created the trust to begin with. Your will only packages also have very limited contingency plans. And so you just want to be very cognizant of what it is that you are creating and accomplishing. The trust plan is probably the first best step, right? It's going to avoid probate, including avoiding guardianships and conservatorships. The plan, when we say plan, it's because it includes the financial powers of attorney. It includes your healthcare powers of attorney. It's a really well-rounded plan to make sure that we're covering a lot of things. Your trust can allow for contingency plans. Everything to my kids. If my kids aren't there, then to my grandkids. And if for some reason I don't have either of them, then I'm going to name it to a charity, or I'm going to name it to a niece or nephew, or I'm going to do something different, okay? With the trust, you can add protections for beneficiaries. You can add the supplemental needs. You can do the different things that we talked about, okay? The next level up is adding those beneficiary protections. That gets added to your trust plan to account for the different needs of the beneficiaries, right? You can still be liberal with beneficiary distributions, and the beneficiary can be their own trustee. That's what I call the just in case plan. I'm not really having any specific concerns about this beneficiary, but I like the idea of beneficiary protections. And so we're going to put those in place just in case something goes sideways that we're not expecting, right? The beneficiary protections instead can be a more conservative type of beneficiary protections with some limits and some oversight by other people. Or it can be very restrictive with drug testing and other requirements, and the beneficiary is never going to be their own trustee, okay? Added to that can be the supplemental needs trust if you have a beneficiary who has some kind of special needs, is receiving government, especially means-based government benefits, all right? So that is specialized language that goes into the trust to avoid disqualification from government benefits. It avoids the disqualification, it avoids the reimbursement, and it allows for contingency distribution so that if any money remains in that special needs trust or supplemental needs trust at the time that the beneficiary passes, you can designate where that money goes to. There's a lot of times when people who have these types of supplemental needs trusts don't have children of their own. And so you are able to designate who's going to benefit from that legacy if this person doesn't need it all during their lifetime. All right. All right, we're getting to the end. So if anybody does have questions, I'm happy to answer them. Please keep in mind that this is a public forum. So keeping your questions generic and not giving away personally identifiable information is really key. This webinar will be on repeat, and so we want to make sure that in addition to not disclosing anything to anybody who's present here today, that we're also not disclosing it to the public in the World Wide Web, right? There's a chat feature in the lower right-hand corner of your screen, and then there you could also just raise your hand or unmute yourself if anybody has any questions. All right. Well, listen, we really thank you so much for joining us today. We hope that you learned something new. We encourage you to discuss any questions you have with a professional, and feel free to reach out to us at Keystone Law Firm. Our email address is info, I-N-F-O, @keystonelawfirm.com. We do have a whole series of webinars that we are covering. Some of them fairly simple estate planning concepts, some financial concepts done by Carmi Gutman, our financial advisor, and then some that can be a little bit more complex that Francisco Servent will sometimes do with regards to other options that are a little bit more complex in terms of investing or irrevocable trusts or asset protection or those types of things. If you ever have an idea for a webinar, please feel free to reach out to us and suggest it. We're wide open to suggestions, but we really appreciate you giving us your time today. We look forward to seeing you in the office or at one of our summits or another webinar. So thank you so much for your time today. Feel free to reach out to us if your questions come up later, and we hope you have a fabulous day. Thanks so much. Bye.